Hello, how are you today? This is Bong-Soo Jung, Korean labor attorney. Today I'd like to introduce one dismissal case by the order of the head office of the multinational company. So this multinational company has a head office in Swiss. So this company is very famous for the electronic the production for the electronic items. So this engineer who once worked in Switzerland, and he was assigned to the Korean branch office for 2 years. Then while he was serving here for 1 year, the company, Korean branch company, received the order from the head office. So this engineer was involved in some wrong transaction with the client. So this was not tolerated. So company investigate this case, and company decided to fire all the managers and the members working in the department. So this engineer belonged to the same department. So the head office dismissed all the staff and managers in that same department. So after they firing all the staffs, so one of the staff was assigned to Korea. So they gave a special order to Korean branch office to fire this person because he was involved in the transaction with the client. So in this case, so this the Swiss engineer was fired, and he visited my office and asked for legal representation for this unfair termination. So I reviewed the case. So this main point is whether the assigned the engineer from abroad can be applicable to Korean labor law. Also, if he is applicable to Korean labor law, then justification for dismissal is acceptable or not. So in this case, company claimed, so company has a policy that is they could not tolerate the wrongdoing for the transaction with the client. Also any the bribe or wrongdoing with the transaction. So regarding those ethic issue, employees signed some agreement for those conditions. So the condition is if the employee was involved in one of those cases, it would be the subject to the immediate termination. So he signed that. So but as a rebuttal document, we explained that this employee was not the player for who was involved in wrong transaction with the client. He was just one of the engineers working in that department. Also, where he is working in Korean branch is independent entity. So he must follow Korean rules of employment and not the head office rules of employment. So in the Korean branch's rules of employment, he's supposed to have some right to state himself to the disciplinary action committee, but there are no disciplinary action held for this case. Also, he didn't have a chance to state his wrongdoing. So that means the company violated disciplinary process rules. So I explained it was unfair termination. So Labor Commission accepted and suggested some settlement before their verdict. So company accepted that. So also we accept as long as they paid all salary until he finished his contract period for remaining 1 year. So finally both party accepted, and we agreed, and we accept this settlement agreement. So that means I successfully represented my client. Okay, this is all. Thank you for watching. Bye bye.